Welcome back to episode 2 of In Sync by Synchronomics, the podcast for everyone who knows that everybody benefits from better benefits. I'm James Holland, and I'm here with my co-host, Jamie Linkowski.
Good to be here, everybody.
Great. Last month, we introduced you to the most important person when it comes to building your benefit programs, ALICE, which was the acronym for Asset Light but Income Constrained and Employed. And ALICE is the very person you should be focusing on when designing your benefit programs. Everything we do here at Synchronomics and everything you should be doing as an employer should be to help protect Alice. But aside from Alice, there's one other incredible person we'd like you to know. He's our third co-founder, tends to avoid the spotlight. He prefers that Wizard of Oz approach behind the curtain, is Rick Canipe, and he'll be joining us shortly. But first, I wanted to set the scene. We are a 24/7, 365 benefit-focused firm, and we realize the vast majority of people do not have the time for that as they need to be focusing on other things. So right now, why are benefit programs so important? We're going to dig into that today. And at a high level, all employee benefit programs are under what's called the Employee Retirement Income Security Act of 1974, otherwise known as ERISA. You'll hear us mention the acronym ERISA a lot, and we'll be talking about that, obviously, in other future podcasts as well. There are a number of regulatory bodies that are involved as well, the DOL, which is the Department of Labor, the IRS, the SEC, and HHS as well. The overarching theme behind ERISA is that you have to solely and exclusively design those programs for the benefit of the participant. You cannot put yourself or any other third party's interest ahead of those employees. So as you can imagine, this could go sideways in a lot of different directions, and we can't possibly touch on all of those in a single podcast. That's the exact reason that we formed Synchronomics and the basic premise behind everything that we do. Over the last decade, we've seen hundreds of employees sue their employers for missteps that have taken place within the 401k space. There's opened a can of worms, a very lucrative one for plaintiffs' bars and their attorneys, and we expect to see more as time progresses. Also, signs are pointing towards healthcare being the next space for this litigation. And we're going to take a deeper dive into that at the end of the podcast. But first, we're going to have a chat with Rick about what's going on with all the 401k lawsuits, the rulings, and how that impacts employers. Joining us now is Rick Canipe, our co-founder at Synchronomics. Rick started his career as an ICBM missile captain in the Air Force before getting into finance. And then he spent many years running employee-sponsored retirement plans for some banks in North Carolina and Virginia that covered employee sizes of all kinds, from mom and pop to large corporations like Wendy's, Papa John's, and Krispy Kreme. But what Rick realized is the biggest benefit, no pun intended, of course, is how to show employers that risk that they have by offering these programs. So he designed a patented tool called the Plan Analyzer that helps an employer analyze the risk and potential violations and or fines or dollar damages they could face in a lawsuit. It's an incredibly powerful tool that we use with a lot of our advisor partners, and we'd love to share with the plan sponsors that we talk to. So Rick, thank you for joining us today.
Thanks for having me.
Great. And one of the key things I wanted to focus in on, again, in April of this year, in Cunningham versus Cornell, there was a Supreme Court decision that came down in favor of the plaintiffs. By the way, which is the third one in the last 10 years that has come down in favor of the plaintiffs. Rick, just take a minute, if you would, and very high level, give us why this is so important for employers to have an understanding of.
Sure. In a nutshell, ERISA came out in 74, and it said you have to act solely and exclusively for the betterment of the worker. And in 1980, they passed an SEC rule 12B1 that radically altered selling investments. It allowed basically an employer to bring a broker in, and that broker can get compensated in a fashion every day the stock market closes at 4 p.m. that's never seen by the worker. In fact, it's hard to see it even by the employer. It's buried deeply inside of what's called a prospectus. So this compensation reduces the employee's balance. That balance reduction can't be felt if you're looking at your statement over a short period of time, but over a longer period of time, they reduce around a third to half of the retirement wealth of the worker.
So, and the 12B1 fee that you're talking about there, revenue sharing stuff we can get into again on different episodes, but has evolved to the point where the industry itself is almost taking care of that because of disclosure rules and everything, therefore shedding some light. But one of the key issues within the Cornell case is not just the reasonableness of that compensation, but the necessary aspect of that advisor or broker that you made mention of, and the importance of documentation, not just by them, but by the employers who are hiring them, correct?
Yes, the employers usually bring a broker in 2/3 of the time to run a plan, and there's somebody they golf with, or usually somebody they know from the neighborhood. And so that person comes in, and the way that they get paid is a natural conflict of interest. So the Supreme Court said you can't get paid anything out of a 401k plan unless you have one of 21 exemptions. And the employers thought, well, this is okay. I'll always have an exemption because I need my broker. But you used the word necessary. If the broker's conflicted, you can see there's probably an issue with being necessary. Necessary means for the worker, not necessary for the broker.
Okay, great. And I guess, and I probably should have started this conversation that we are not lawyers. We do not play one on television. This is folks who have, between the three of us, 30 plus years of ERISA experience and expertise when it comes to retirement plans. So we're not opining on anything legal. We're just looking at the cases that have already been put in place as far as that goes. So one of the key things here, though, Rick, I think, is the fact that the Supreme Court is basically told, and I'm going to paraphrase a little bit here, and I'm probably going to overgeneralize, but basically has told the plaintiff's bar, hey, all you have to do is basically plead that something is wrong, and then it becomes the responsibility of the employer to prove, in fact, they did not do that. Is that a fair assessment?
Yes, basically the pleading standard got reduced to basically the plaintiff or the former employee in most cases simply has to say that they don't believe the broker was necessary because the investments the broker picked paid the money somehow. And that employer then has the burden shifted to prove how that compensation was not excessive and that the compensation was absolutely necessary.
Okay, so then when the litigation wave train, whatever cliche you want to use with regards to retirement plans started, 10, 15 years ago, it was only the jumbo plans or the super large ones that were coming under attack. With this new flexibility, do you see it possibly coming down market in terms of plan size, employer size?
Yeah, I think because the pleading standards lowered so much from this third unanimous ruling by the Supreme Court, that plaintiff's bar, the attorneys who litigate in this space, can have an easier time getting past a motion to dismiss. That means basically they win because what usually occurs next is a settlement. So a plan that has, say, 20 million, 30 million could be at risk when before they were 3 billion in size.
Got it. Great. Okay. Well, now that we've done all the doom scrolling and all the other things to almost scare the plan sponsor into shutting down the retirement plan, let's try to end this part on a positive note if we can. Having access to this information now in terms of the Supreme Court rulings and the new disclosure and other information, this should also but empower employees to then have more control so they can have the conversation with their employer prior to it becoming a legal matter. Do you agree or disagree?
Yes, every year in July, the employer has to send a document to the government. So the IRS Department of Labor has a website that the employees can go to, and they can see how much the broker's paid. And the plan sponsor, the employer, can easily go look at what they've sent in the last years. And if they see that someone's made $50,000 then that 50,000 needs to be necessary. That money needs to be for a benefit to the worker. And then you have to assess, is $50,000 enough to go in and do 2 meetings a year? Is it too much to do 2 meetings a year, or is it just right?
Yep, which again leads to that conversation we were talking about for all folks to get involved. So what we want to do there is take a look at the opportunity to say, hey, Mr. Employer, hey, Miss Employee, here's a chance. We have some publicly available information. All we're looking for is the best outcome for all of us, because the employer obviously wants, and this is what goes back to what Janie and I discussed in the first episode, you want to have happy, productive, focused, energized employees. And that takes a little bit of engagement from on the employer side to ask some very basic questions about the advisor consultant being brought in. Again, how many meetings? What are you discussing? Are you giving actual advice or just education? There's a whole host of other things. But again, 3 for 3 from the Supreme Court. And I believe there's a 4th one coming down the pipe, potentially, Rick, in the Pizarro versus Home Depot. I don't know if they've actually set a date, but I think there's also that one that might come before the court in their next set of hearings. Well, thank you, Rick. That was a terrific breakdown, and with regards to not just the regulatory environment, but the Cornell case as well. It's going to be very interesting to see where those things head. Many experts are looking at similar cases now drifting over towards the healthcare side. So here we're going to bring in my co-founder, Jamie, and talk a little bit about accountability on the healthcare side and what employers should be looking for in terms of protecting themselves and their employees.
Yeah, I'd like to unpack a little bit of what Rick just went over. We've always looked at all of these issues in 3 ways. One is the legal, which Rick nails, right? Then there's the technical piece. And then for our viewers, there would be the practical piece of what does that mean? And then what I call, so what now? What do we do about that? The first thing is changing that burden of proof, right? That pleading standard that he talked about. The bar has now become very low to proceed with litigation when you find out that Alice and or your plan participants are being harmed. And Rick touched on something very technical, right? It's not just the reasonableness of it. It is it necessary, not just to the operation of the plan, which is one perspective, but is it necessary for the employees, and in this case, the healthcare members of the plan? And so if you are paying unreasonable fees to conflicted brokers that aren't necessary to the employees of the plan, we may have an issue. And again, you can lob, there are a lot of plaintiff firms circling, you can lob a lawsuit very simply, and the burden of proof will be on the employer. So there's a lot of legal and technical things to navigate here in that regard. From a practical situation, there'll be a big emphasis going forward for all employers as it relates to benchmarking those fees. Are they reasonable? Are they necessary for the operation? Are they necessary for the members of the plan? The documentation, right? Documentation of that information in terms of your books and records, a vendor review for sure, and then what that level of compensation is against the vendor roles and responsibilities. So there's a lot to unpack there.
So I guess, Jamie, then one of the things that we've kicked around is, why haven't we seen the shift, I guess, on the healthcare side as quickly as we saw it on the 401k side? So people were angry at the insurance companies. We hear about that all the time. Obviously, the United Healthcare CEO, horrible incident that took place, things along those lines. What is going to be that tipping point that gets the employees to say, wait a second, hey, Mr. Employer, you're the one who hired these folks, and then being able to start connecting those dots? What do you think is going to happen? How does that transition take place, or does it?
I think we'll get there. A couple of things from a legal standpoint. If you recall, the Tibble result took a long time, and then that was a watershed moment. And then you had a lot of law firms just pile on, and there are a lot of Me Too lawsuits. On the healthcare side, I think the passing of the CAA, which just happened in 2021 and then had some real teeth to it, that's just that's recent, right? I think Tibble took 10 years to settle, if I recall correctly, James. So
Yeah.
we're still only 5 years out. I hate to say that. Hopefully we're ahead of what retirement is, where, we're proactively helping employers because we could look back to the precedents of the retirement side. So in some ways, I actually think we're ahead. I will say that I don't know that a lawsuit has actually successfully against an employer has been filed and successfully won just yet. Because of, again, legal and technical things that you and Rick know more about, the Article 3 standing, etc. Someone just hasn't broken through yet. But once that happens, the floodgates will open just as they did in retirement.
And there are people, again, you have that conversation with the employer who doesn't think they're at risk. They don't have a bad program. A lot of that, I mean, where is that coming from? Where is it just blind faith in people they hire? Are they not? Are they too engaged in other aspects of the business? What's preventing them from wanting to take that deeper dive to find out which side of the fence they fall on?
So I think that's a bunch of trends. You just have the way that healthcare has been sold traditionally. 20 years from now, before high deductible health plans, employers paid most of those costs. They then got really expensive, maybe underneath their noses, and the plan cost shifting happened, higher and higher deductible plans, copays and coinsurance. And then all of a sudden, here we are with an aging demographic that can't afford to retire. That's why Synchronomics really looks at this through two lenses. And now you've got an aging demographic that can't afford to retire with a bunch of chronic diseases or high cost claims. And all of a sudden, you're talking about real EBITDA that is being eaten by healthcare, right? And now you're passing on more of those costs to that Alice demographic. So you're basically creating future plaintiffs who are really unhappy with the result.
Yep. And that goes back to Rick's point in terms of the potential conflict. So the person that they hired to help them design or put these benefit plans in place, who some may believe work for them, actually get paid by somebody else. And that's one of the areas that they probably should spend a little more time focusing on.
Yeah, it's interesting. The idea of clearing conflicts kind of gets overlooked. And a lot of the things that we're seeing already in the public arena and over social media are folks that are still conflicted and using the words. But if you would try and clear conflicts, they wouldn't pass, square one. So we're not there yet, but it's going to come.
Gotcha. Great. Again, we could talk about disruption in the healthcare for hours, which we probably will over a whole bunch of different episodes, but we're going to take a minute now and we'll wrap up this episode because there's so much education that needs to be done for both the employees and the employer that we'll have to save that for some other time. Okay. One of the things that we also, JD is famous. He loves his so what, now what. One of the things that we focus here on Synchronomics is, again, when you get a diagnosis at the doctor and it's very serious, what's the first thing that pops into your mind? I'm going to go get a second opinion. So all we're saying is get a second opinion. When you're looking at these things, take the time to have the assessment done. Make sure the person or the people you go to are independent. Obviously, they have to be qualified from an experience standpoint and obviously unconflicted. So again, if you'd like to go to www.synchronomics.com. It gives you some ideas on some of the different programs we have with regards to doing that assessment for employers. And again, it's irregardless of the size of the plan. Well, thank you all for joining us again. And we'll be right back next month for another episode where hopefully we'll bring on another expert guest to talk a little bit more about the impact that's having on employees when it comes to their different benefits and why this industry is so ripe for disruption.